Your property ends where I say it does. That was the line Lorraine Kingsley, president of the Silver Pine Estates HOA, shouted in my face when I questioned the boundaries of my family's land. She stood there with a stack of zoning files thick enough to stop a bullet, the confidence of someone who wielded power radiating like impenetrable armor. I had seen that type before, authority built on paperwork and ego inflated beyond reason. What she didn't know was that I had the original 1947 survey map and the patience of a man with nothing left to lose. And what she certainly didn't know was that the 512 homes she had just finished building on my land were about to become mine. All of it. Leave a comment below where you're watching from. And let me know if you've ever faced an abusive HOA. March of 2019 started quietly for me, the way most endings do before they announce themselves. I was standing by the window of my grandfather's old cabin, coffee going cold in my hand, watching a line of bulldozers roll into the eastern woods. That forest, thick with oak and pine, had been in my family since my grandfather William Cross bought the tract from the Bureau of Land Management back in 1951, 127 acres of Virginia hill country, most of it untouched, except for the narrow dirt road leading to this cabin, where I had been living alone for 3 years since my wife passed. The trees were just starting to bud, that pale green that comes before spring fully commits, and the morning light slanted through them in a way that made everything look fragile and temporary. I pulled on my boots and walked down the slope toward the construction site. The air smelled like diesel and fresh-cut wood, a combination that sat heavy in my lungs. A crew of about a dozen men was marking stakes in the ground, orange flags snapping in the wind like tiny surrender signals that nobody was paying attention to. I reached the clearing and held up the faded metal sign I had hammered into a post years ago, the one that read private property, no trespassing. The site supervisor, a man in a yellow hard hat with a clipboard tucked under his arm, glanced at me like I was a stray dog that had wandered onto a job site. He said the crew had been authorized by Silver Pine Estates HOA to start Phase 3 of a 512-unit residential development. If I had a problem, he told me, I should call the HOA president. Then he turned his back and kept barking orders into his radio. I walked back to the cabin, my pulse steady, but my mind already cataloging what I knew and what didn't add up. The land had never been part of any HOA, never been rezoned, never been listed in any community development plan I had ever seen. My grandfather bought it outright, paid in full, received a deed recorded with the county, and when he passed in 1998, the property transferred to me with a clean title. I opened the steel lockbox under my desk and pulled out the original survey map. The paper was yellowed and brittle at the edges, but still legible. The boundaries drawn in ink with every corner marked by coordinates that had been verified by the Bureau of Land Management in April of 1947. The tract included the exact area where those bulldozers were tearing up the soil. That evening, a letter arrived in my mailbox, typed on HOA letterhead, with a logo that looked like it cost more to design than I made in a month. It was signed by Lorraine Kingsley. The letter informed me that the area I was occupying violated HOA regulations, and that I was required to vacate or face a fine of $250 per day, starting immediately. I read it twice, my hands tightening around the edges of the paper until it creased. The cabin was silent, except for the hum of the refrigerator, and the distant sound of chainsaws echoing through the valley like a slow amputation of everything my grandfather had built. I thought about his voice, rough and steady, telling me the summer before he died that this land was the one thing they could never take away, as long as I kept the original documents safe. He had been wrong about a lot of things in his life, but I didn't think he was wrong about that. I didn't sleep much that night. I kept going over the details in my head, the timeline, the paperwork, the fact that someone had authorized construction on land they did not own. By the time the sun came up, I had made a list of questions I needed answers to. Who approved the zoning change? When did it happen? Who signed off on the permits? And most importantly, how did my name end up on documents I never touched? I made coffee, thick and bitter the way my grandfather used to drink it, and stood at the window again, watching the yellow machines crawl across what used to be forest. The sound of saws biting into oak trees carried on the wind, rhythmic and relentless, and I felt something cold settle in my chest. Not angry yet, just clarity. The kind that comes when you realize someone has made a serious mistake, and you are the only one who knows it. I pulled the survey map from the lockbox one more time, this time noticing something I hadn't paid attention to before. There was a handwritten note in the margin, faded but still visible, in my grandfather's blocky script. It read, "County copy filed June 51. Keep this safe." That meant there should have been a duplicate on record at the county office, which meant someone would have had to alter or remove it to make their fake zoning documents look legitimate. I folded the map carefully and slid it back into the lockbox. Then I picked up my phone and started searching for a real estate attorney who specialized in fraud. I drove into town the next morning with a folder full of documents on the passenger seat. The HOA office was located in a renovated brick building on the edge of the Silver Pine Estates development, the kind of place that tried too hard to look welcoming with its potted flowers and hand-painted welcome sign. I parked in front and walked through the glass doors at 9:30 a.m. The receptionist, a woman in her 20s with a headset and a smile that didn't reach her eyes, told me Lorraine Kingsley would see me in a few minutes. I sat in the waiting area, surrounded by framed photos of happy families standing in front of cookie-cutter homes, and tried to keep my breathing steady. Lorraine walked out of her office exactly 12 minutes later. She was 53 years old, tall and sharp-edged, dressed in a gray suit that looked like it had been tailored to intimidate. She didn't offer to shake my hand. Instead, she gestured toward her office and said I had 10 minutes because she had a planning committee meeting at 10 a.m. I followed her inside, a space dominated by a large desk covered in binders and a wall of framed certificates that I assumed were meant to establish credibility. I set the folder on her desk and opened it, pulling out the photocopy of my grandfather's deed and the original purchase contract from 1951. I told her the land her development was being built belonged to me. She barely glanced at the papers before pushing them back across the desk. She said the documents were outdated and no longer held legal weight because the land had been rezoned in 2017 under a new county development plan. She pulled a thick binder from her shelf and flipped it open, pointing to a page that listed the tract as part of the Silver Pine Estates Community Zoning District. I asked her how land could be rezoned without the owner's knowledge or consent. She leaned back in her chair, her expression flat and dismissive, and said that proper notice had been given and that all procedures had been followed according to state law. Then she told me that if I had any further complaints, I should take them up with the county planning office because she had 512 families relying on this development, and she wasn't going to let one stubborn individual hold up progress. The way she said it, calm and practiced, made it clear this wasn't her first time burying someone under legal jargon. I left the office with my folder tucked under my arm and a cold knot forming in my stomach. By 2 p.m., I was at the county clerk's office requesting copies of the 2017 zoning application. The clerk, a tired-looking woman with reading glasses on a chain, pulled the file from the archives and handed it over without comment. What I found made my hands go numb. The application listed the property owner as Silver Pine Estates HOA, and it included a signature on the consent form, my signature, except I had never signed anything. The handwriting was close but not perfect, the kind of forgery someone might pull off by scanning an old signature from another document and pasting it onto new paperwork. There was also a mailing receipt attached, showing that legal notice had been sent to an address I hadn't lived at in over a decade, an old P.O. box I had closed after my grandfather died. Someone had known enough about my family's history to make the forgery look legitimate, but had counted on the fact that I wouldn't receive the notice in time to object. That evening, Lorraine called an emergency HOA meeting. I wasn't invited, but I heard about it the next morning from my neighbor, an older man named Roger who lived about 2 miles down the road and had been trying to stay neutral in whatever was brewing. He told me Lorraine had stood in front of a packed community center and painted me as a selfish obstructionist who was trying to derail a project that would bring affordable housing to over 500 families. She called me greedy, said I was fabricating ownership claims to extort money from the HOA, and suggested that I was mentally unstable after the death of my wife. Roger said the room had erupted in applause when she finished. Within hours, she had sent a mass email to every HOA member with the subject line, "Urgent threat to our community," complete with a one-sided summary of the dispute and a call to action encouraging residents to avoid any interaction with me until the matter was resolved. The isolation came fast. I went to the general store to pick up groceries, and the cashier refused to ring me up, saying the owner had decided not to serve anyone, causing trouble for Silver Pine families. I tried to fill up my truck at the gas station, and the attendant, a guy I had known since he was in high school, looked at me with something worse than anger, pity. He said he couldn't stop me from using the pump, but asked if I really thought it was worth tearing apart a whole neighborhood just to prove a point. I didn't answer. I just paid and left, the shame of being misunderstood sitting heavier on my chest than any insult could have. I sat in my truck outside the gas station, engine idling, watching a group of mothers with strollers walk past and deliberately avoid looking in my direction. I thought about how easy it is to destroy someone's reputation when you control the narrative, when you have a platform and an audience that wants to believe you. Lorraine had done this before. I was certain of it. She knew exactly how to weaponize a community, how to turn neighbors into enforcers without ever having to lift a finger herself. But she had made one critical miscalculation. She assumed I would break under the pressure, that I would take whatever settlement she offered and disappear quietly. What she didn't realize was that I had the one thing she couldn't fake or bury, the original deed. And I was just getting started. I needed a lawyer, and not just any lawyer. I needed someone who understood real estate fraud, someone who had seen this kind of corruption before and knew how to dismantle it piece by piece. I spent 2 days making calls, leaving messages with firms that either didn't return them or politely declined once they heard the name Silver Pine Estates. On the third day, I got a call back from James Caldwell, a 59-year-old attorney who had built his reputation on taking cases nobody else wanted. His voice was rough, like gravel scraped across pavement, and he told me to come to his office in Richmond the next morning at 8 a.m. sharp. Caldwell's office was on the second floor of a building that looked like it had been standing since the Civil War, all exposed brick and creaking floorboards. He sat behind a desk piled with case files and legal briefs, a man with silver hair and a face that had spent decades weathering courtroom battles. I walked him through the timeline, starting with the construction, the forged signature on the zoning application, and the notice sent to a closed address. He listened without interrupting, occasionally making notes on a yellow legal pad, his expression unreadable. When I finished, he leaned back in his chair and asked me one question. He said, "Do you want to win? Or do you want to make a point?" I told him I wanted both. He said we would start by requesting the full zoning file from the county under the Freedom of Information Act, then move to subpoena internal HOA financial records if we could establish probable cause for fraud. He had contacts at the county clerk's office from 30 years of litigation work, people who knew which files were buried and which signatures looked off. He also had access to corporate registry databases that could trace shell companies across state lines, a skill he'd honed from dealing with developers who liked to hide money in Delaware and Nevada. It would take time, he warned, and it would cost money I might not get back even if we won. But if the forgery was as clear as I said it was, we had a case. He agreed to take me on and told me to go home and let him do what he did best. I left his office feeling something I hadn't felt in weeks. Not hope, exactly, but the cold certainty that someone was finally taking this seriously. 3 weeks later, Caldwell called me with news. The county had released the zoning file, and buried in the procedural paperwork was a payment receipt that didn't match the official timeline. It showed a consulting fee of $650,000 paid to a shell company called Clearview Advisory, LLC, processed 2 months before the zoning application was even submitted. Caldwell traced the company registration through a Delaware corporate database and found that it had been formed with a single listed officer, a woman named Sandra Voss, who turned out to be Lorraine Kingsley's sister-in-law. The money had moved through 3 accounts before landing in a private trust that Lorraine controlled. It was a classic kickback scheme, designed to look like legitimate consulting work, but structured to funnel HOA funds into her personal accounts. But that wasn't the worst part. Caldwell had also managed to pull old financial records from the development project itself, records that showed the land had been sold to Redwood Pinnacle Development LLC for only $1.2 million when the market value, based on comparable sales, should have been closer to $8.5 million. The difference, over $7 million, had effectively been stolen from me before I even knew the land was being taken, and the person who had brokered that sale, according to the signed agreements Caldwell uncovered, was Lorraine Kingsley acting as an agent of the HOA. She had personally negotiated the deal and earned an 8% commission on the final sale price, which came out to just under $96,000 deposited directly into her account. What made the sale possible, Caldwell explained, was a second forged document, a notarized authorization to sell that bore my name but had been signed by someone else and rubber-stamped by a notary who had since retired and moved out of state. I sat in Caldwell's office, staring at the stack of documents spread across his desk, and felt my understanding of the situation shift into something darker and more deliberate. This wasn't a bureaucratic mistake. It wasn't incompetence or a failure of oversight. Lorraine Kingsley and the developer, a man named Gerald Moss, who ran Redwood Pinnacle, had conspired to steal my land, forge the paperwork, and profit from a project worth $89.4 million. The 512 homes weren't just a real estate development. They were the product of a calculated fraud that had been in motion since at least 2016, long before construction ever started. Caldwell said we had enough to file a lawsuit and notify the FBI. Real estate fraud involving forged documents and interstate financial transactions, especially when shell companies were used to move funds across state lines, automatically triggered federal jurisdiction once a formal complaint was submitted. He recommended we move fast before they had time to cover their tracks any further. I told him to file everything. I wanted the lawsuit on record, the FBI notified, and every document we had submitted as evidence. I wanted it done right, done legally, and done in a way that left no room for them to claim ignorance or plausible deniability. That night, I sat on the porch of the cabin and looked out at the construction lights glowing in the distance, the skeletal frames of houses rising against the darkening sky. For weeks, I had carried the weight of being misunderstood, of being painted as the villain in someone else's story. But now the narrative was shifting. I wasn't the obstacle anymore. I was the plaintiff. And every piece of evidence Caldwell had uncovered was another nail in the coffin of the lie Lorraine had built her empire on. She had stolen from me, slandered me, and assumed I would never have the will to fight back. She was wrong, and soon everyone would know it. By August of 2019, Caldwell had assembled a case file that could have doubled as a textbook on real estate fraud. We filed the civil lawsuit in the Circuit Court of Henrico County on a Tuesday morning at 9:15 a.m., naming Lorraine Kingsley, Gerald Moss, Redwood Pinnacle Development LLC, and the Silver Pine Estates HOA as defendants. The complaint ran 42 pages and included 3 primary counts: fraud in the inducement for the forged signatures, trespass and conversion for the unauthorized use of my land, and unjust enrichment for the profits they had extracted from a property they never legally owned. Caldwell also filed a motion for a temporary restraining order to halt construction on Phase 3, the final 150 homes that had not yet been completed. His argument was straightforward: ongoing construction was causing irreparable harm by permanently altering property boundaries and destroying the evidentiary integrity of the original land survey. The hearing was scheduled for 10 days later. At the same time, Caldwell submitted a formal complaint to the FBI field office in Richmond. Real estate fraud involving forged notarized documents and the use of interstate shell companies to launder proceeds fell squarely under federal wire fraud statutes, and because the development had received financing through federally backed loans from the Federal Housing Administration, the case also triggered potential violations of federal lending regulations. The FBI didn't move fast. Caldwell warned me, but once they opened an investigation, they were thorough. He estimated it would take 3 to 6 months before we saw any criminal charges, but the civil case would move faster, and that was where we needed to focus our energy. I spent the next week helping Caldwell gather every piece of documentation we could find. I requested certified copies of every land transaction associated with my tract, going back 70 years, a process that required 2 separate trips to the county archives because records older than 30 years had been transferred to off-site storage and required special retrieval requests. I also pulled tax records showing I had been paying property taxes on the full 127 acres every year, without interruption, which contradicted the HOA's claim that the land had been legally rezoned and transferred. Caldwell hired a handwriting expert, a retired forensic analyst named Dr. Patricia Crane, who examined the forged signatures on the zoning application and the sales authorization. Her report was unambiguous. The signatures were not mine. The pressure points were inconsistent with natural handwriting, and more critically, she identified horizontal printer banding visible under magnification, evidence that the signature had been scanned from another document and digitally reproduced rather than signed by hand. The temporary restraining order hearing took place on August 23rd at 2 p.m. in a courtroom that smelled like old wood and floor polish. Lorraine showed up with 2 attorneys from a firm in Richmond, both of them in tailored suits and carrying leather briefcases that probably cost more than my truck. Gerald Moss sat in the back row, arms crossed, looking like a man who had been through this before and wasn't particularly worried. Caldwell stood at the plaintiff's table in a rumpled blazer and presented our case with the kind of calm precision that comes from decades of courtroom work. He walked the judge through the timeline, the forged documents, the fake consulting fees, the sale of my land for a fraction of its value, and the 8% commission Lorraine had pocketed. He presented Dr. Crane's handwriting analysis and the tax records showing uninterrupted ownership. The defense tried to argue that the zoning had been legally processed, that I had been properly notified, and that any dispute over signatures was a matter for criminal court, not civil remedies. One of Lorraine's attorneys, a younger man with wire-rimmed glasses, pushed back aggressively, claiming that halting construction would harm over 500 families who had already purchased homes in good faith, and that the plaintiff's claims were based on outdated documents that had been superseded by modern zoning law. He argued that even if there were procedural irregularities, the appropriate remedy was monetary damages, not a construction freeze. But when the judge asked them to produce evidence that I had ever consented to the sale or the rezoning, they couldn't. The notice had been sent to a closed address. The signatures were demonstrably forged, and there was no record of any contact between me and the HOA before March of the judge, a woman in her 60s named Miriam Sutherland, who had a reputation for not tolerating nonsense, granted the temporary restraining order. She halted all construction on Phase 3, effective immediately, and ordered Redwood Pinnacle to preserve all financial records related to the Silver Pine project pending further review. She also scheduled a full evidentiary hearing for early November and made it clear that if the fraud allegations held up, she would consider far more severe remedies than just stopping construction. I walked out of the courthouse that afternoon and felt the first real shift in momentum since this whole nightmare started. Construction equipment sat idle in the distance, orange cones blocking the entrance to the Phase 3 site. Lorraine and Gerald stood on the courthouse steps, surrounded by their legal team, and I could see the cracks starting to form. Lorraine's face was pale, her jaw tight, and Gerald was on his phone barking orders at someone in a voice loud enough to carry across the parking lot. Caldwell put a hand on my shoulder and told me this was just the beginning. The restraining order was a victory, but the real fight would come in November when we had to prove not just that the documents were forged, but that the entire development had been built on stolen land. That night, I drove out to the edge of the construction site and parked where I could see the unfinished frames of Phase 3 standing dark against the horizon. For the first time in months, the sound of machinery was gone. No saws, no hammers, just silence and the distant hum of crickets. I sat there for a long time, engine off, windows down, letting the cool air settle around me. It wasn't over, but for the first time, I wasn't fighting alone in the dark. The system, slow and frustrating as it was, had finally started to recognize what had been done, and that was enough to keep going. The full evidentiary hearing was scheduled for November 7th at 10 a.m., and in the weeks leading up to it, Caldwell focused on one critical piece of the puzzle, the land survey. He subpoenaed financial records from Redwood Pinnacle, communications logs from the HOA board, and, most importantly, he issued a subpoena to Silverline Surveying, the firm that had provided the supposedly independent land survey used to justify the rezoning and the sale. The survey, dated April 18, claimed to have verified the property boundaries and confirmed that the land in question fell within the jurisdiction of the Silverpine Estates HOA. Caldwell didn't believe it. He wanted the surveyor who had signed the report, a man named Marcus Holt, to testify under oath. Marcus was a 41-year-old licensed land surveyor who had worked for Silverline for nearly 15 years. When Caldwell tracked him down and served him with the subpoena, Marcus tried to delay, claiming scheduling conflicts. Caldwell wasn't interested in excuses. He filed a motion to compel testimony, and the judge granted it. What Caldwell didn't tell me until later was that Marcus had already been quietly questioned by his own company's internal compliance team after Silverline received the subpoena, and the firm had put him on administrative leave pending the outcome of the hearing. Marcus knew he was walking into court with no protection from his employer and no guarantee of immunity. If he lied under oath, he was facing perjury charges on top of everything else. The courtroom on November 7th was packed. Local news crews had started covering the case after the temporary restraining order made headlines, and the story of a man fighting to reclaim his stolen land from a corrupt HOA and a multi-million-dollar developer had the kind of narrative weight that attracted attention. I sat next to Caldwell at the plaintiff's table, watching as Lorraine and Gerald entered with their legal teams, both of them looking more tense than they had in August. The judge, Miriam Sutherland, took her seat at 10 a.m. sharp and called the hearing to order. Caldwell stood and requested permission to call Marcus Holt as a witness. The bailiff opened the rear doors, and Marcus walked in, looking pale and uncomfortable in a suit that didn't quite fit. Caldwell didn't waste time. He asked Marcus to confirm that he had signed the April 2018 survey report for the tract in question, and that the report had been used as supporting evidence in the rezoning application. Marcus said yes, his voice quiet but steady. Caldwell then asked him to describe the process he had used to conduct the survey. Marcus explained that he had visited the site, taken GPS readings at key boundary markers, cross-referenced them with county records, and prepared a report based on his findings. It all sounded professional and thorough. Then Caldwell asked the question that changed everything. He said, "Marcus, did you personally conduct this survey, or did someone else do the field work?" Marcus hesitated. The courtroom went silent. Marcus shifted in his seat, his hands gripping the edge of the witness stand. He said he hadn't personally visited the site. The survey had been based on an older report from 2005 that Silverline had conducted for a different property dispute in the area. His supervisor, at the time, a man who had since left the company, had told him the terrain was relatively unchanged, that most of the original boundary markers had been lost or overgrown, and that it was acceptable to rely on archived GPS data rather than resurveying from scratch. Marcus said he had assumed the process was standard, that it was just administrative cleanup for a tract that had already been documented. But when Caldwell pressed him, asking if he had verified the boundary markers himself or cross-checked the coordinates against current data, Marcus admitted he had not. The survey report he had signed was essentially a photocopy of an outdated document with superficial modifications. Caldwell asked Marcus if he had been paid anything beyond his standard salary for signing the report. Marcus looked down at his hands and said, yes. Gerald Moss had personally given him $45,000 in cash, delivered in 3 unmarked envelopes over 6 months, always handed to him in the parking lot of a grocery store after hours with no receipts and no documentation. Gerald had called it a consulting fee for expedited services. Marcus said he had known it didn't feel right, but he had debts, a mortgage, and had convinced himself that he wasn't doing anything technically illegal since the coordinates were close enough and the land was going to be developed anyway. Caldwell then presented an email Marcus had sent to Gerald in March of 2018, an email that had been recovered during the discovery process. The email read, "Just sign it. No one checks old surveys." Marcus went quiet. The defense attorneys tried to object, arguing that Marcus's testimony was coerced and that the email was taken out of context. But Judge Sutherland overruled them. She asked Marcus directly if he had falsified the survey report. Marcus sat there for a long moment, the weight of the courtroom pressing down on him, and then he said yes. He had falsified it. The boundary markers he claimed to have verified didn't exist in the locations listed on the report. The coordinates had been copied from an old file, and the entire document had been fabricated to support a sale that Gerald Moss needed to look legitimate. The courtroom erupted. Reporters scribbled notes, spectators whispered, and Lorraine's attorneys huddled together in a panic. Within hours, the story broke wide. Local news ran headlines about a land surveyor confessing to fraud under oath, and the implications spread fast. If the survey was fake, then the rezoning approval was based on falsified evidence. If the rezoning was invalid, then the sale of the land to Redwood Pinnacle was void. And if the sale was void, then every home built on that property, all 512 of them, had been constructed on land that was never legally transferred. The people who had bought homes in Silver Pine Estates, families who had taken out mortgages and moved in expecting secure ownership, suddenly found themselves in legal limbo. Their anger, which had been directed at me for months, began to shift toward Lorraine and Gerald. The community that had been weaponized against me was starting to fracture. I left the courthouse that afternoon and walked to the parking lot where Caldwell was waiting by his car. He looked exhausted, but satisfied, the kind of tired that comes after a hard-won battle. He told me this was the break we needed. Marcus's confession had severely weakened the defense's position, stripping away their credibility and forcing them to explain how they had built $89.4 million worth of real estate on forged documents and falsified surveys. The criminal investigation would accelerate now. The FBI would move faster with a confession on record, and the civil case had momentum we couldn't have hoped for a month ago. I walked to my truck and sat behind the wheel for a moment, not starting the engine, just listening to the sound of people leaving the courthouse, car doors slamming, voices fading. For the first time in 7 months, I felt like I could breathe without the weight of being called a liar pressing down on my chest. The confession triggered a chain reaction that moved faster than anyone expected. Within 48 hours of Marcus Holt's testimony, the FBI executed search warrants on the offices of Redwood Pinnacle Development and the Silver Pine Estates HOA. The Bureau had already been quietly monitoring the case since Caldwell filed the initial complaint in August, and Marcus's admission of falsified documents, combined with evidence of interstate wire transfers crossing the federal fraud threshold, gave them the legal basis to move immediately. Federal agents seized computers, filing cabinets, financial records, and communication logs, hauling boxes of evidence out of both locations while news cameras recorded every moment. Gerald Moss was arrested at his home in Richmond on the morning of November 10th at 6:30 a.m. and charged with wire fraud, mail fraud, and conspiracy to defraud. He was denied bail after prosecutors presented evidence of 3 offshore accounts in the Cayman Islands, a one-way ticket to Panama City purchased 2 days after the November 7th hearing, and a prior civil settlement in Arizona that he had fled before completion. Lorraine Kingsley was arrested the same afternoon at the HOA office, charged with the same counts, plus an additional charge of embezzlement for the consulting fees funneled through the shell company. Her assets were frozen pending trial. The collapse was total, and it was public. Local news stations ran coverage of the arrests on every evening broadcast, and national outlets picked up the story within days. The narrative had shifted completely. I was no longer the greedy holdout blocking progress. I was the victim of an elaborate fraud scheme orchestrated by people who had weaponized an HOA and a development company to steal land and profit from it. The community that had shunned me, that had refused to sell me groceries or let me fill up my truck, suddenly found itself on the wrong side of a story that was being told to millions of people. Some residents apologized. Most stayed silent. A few doubled down. insisting that even if Lorraine and Gerald had done wrong, I should have settled quietly instead of dragging the entire neighborhood into a legal nightmare. But the real damage was financial and structural. 3 days after the FBI arrests, 2 of Redwood Pinnacle's primary construction lenders issued default notices and demanded immediate repayment of outstanding loans totaling $78 million. Without access to credit and with Gerald's personal accounts frozen, the company had no way to meet payroll, pay contractors, or service its debts. On November 15th, Redwood Pinnacle filed for Chapter 11 bankruptcy protection, citing liabilities that exceeded $120 million. The bankruptcy filing revealed that Gerald had diverted funds into personal accounts and offshore trusts, money that was supposed to go toward infrastructure and community development. Banks pulled funding from other projects Gerald had been involved in. Contractors filed liens. Suppliers demanded payment. The entire operation unraveled in less than 2 weeks. The people who had purchased homes in good faith, families who had poured their savings into what they thought was secure real estate, suddenly found themselves trapped. Their mortgages were valid, but the legal status of their property ownership was in question. If the original sale of my land to Redwood Pinnacle was ruled void, then every title in the development could be invalidated. Homeowners organized meetings, hired their own attorneys, and demanded answers from a dissolved HOA board that no longer existed. Some families tried to sue Redwood Pinnacle for fraudulent misrepresentation, but the company had no assets left to pay them. Others directed their anger at the county for approving the zoning change without proper verification. It was chaos, and it was spreading. Caldwell told me the civil case was almost over, with Marcus's testimony, the forged documents, and the FBI's criminal charges. There was no credible defense left. The only question now was what remedy the court would impose. Caldwell was pushing for a declaratory judgment that could potentially recognize me as the sole legal owner of the entire tract, including all structures built on it. He was careful to frame it as a possibility, not a certainty. Courts didn't like displacing innocent homeowners, he said, but they also couldn't ignore the fact that the land had never been legally transferred, and the entire development was built without my consent. Under property law, improvements made on land without the owner's permission can become the property of the landowner. But how that would be applied in a case involving over 500 families was uncharted territory. Whatever happened, the final hearing in December would be the moment when everything was made official, when the lies were stripped away, and the truth was entered into the permanent record. I spent the rest of November watching the collapse unfold from a distance. News helicopters circled the Silver Pine site. Protesters gathered outside the empty HOA office. Some people called me a hero. Others called me vindictive. I didn't care much about either label. I had never wanted to be the center of a national story. I had just wanted my land back, and I had wanted the people who stole it to face consequences. And now, slowly and messily, that was happening. One evening in late November, I drove into town for the first time in weeks and stopped at the general store that had refused to serve me back in April. The same cashier was at the register. She looked up when I walked in, and for a moment, neither of us said anything. Then she nodded, just once, and asked if I needed help finding anything. I bought coffee and a newspaper and left. It wasn't an apology, but it was an acknowledgement. The world had shifted, and people were starting to see what had been there all along. I drove home as the sun dropped behind the ridge. The sky streaked with orange and violet, and for the first time in months, I felt like the weight I had been carrying was starting to lift. Not gone, but lighter, and that was enough. The final hearing was scheduled for December 19th at 10 a.m., and the courtroom was packed tighter than it had been for any previous session. News crews lined the hallway outside. Spectators filled every seat. Homeowners from Silver Pine Estates sat in clusters, some hopeful, some resigned, all of them waiting to hear what would happen to the properties they had bought in good faith. I sat next to Caldwell at the plaintiff's table, watching Judge Miriam Sutherland take her seat and call the court to order. Lorraine Kingsley sat at the defense table with her attorney, looking thinner and paler than she had 2 months ago, her confidence stripped away and replaced with something closer to exhaustion. Gerald Moss was not present. He was in federal custody awaiting trial and had waived his right to attend the civil proceedings. Caldwell stood and delivered his closing argument with the kind of quiet authority that didn't need theatrics. He reminded the court of the unbroken chain of ownership from 1951 to the present. The forensic confirmation of forged signatures, Marcus Holt's confession regarding the falsified survey, and the financial trail leading to offshore accounts and shell companies. He requested a declaratory judgment recognizing me as the lawful owner of the tract and all structures built upon it, as well as findings of fraud and unjust enrichment that would support the ongoing federal prosecution. His presentation was concise, focused on the legal implications rather than rehashing every document we had already submitted. The defense attorney, a man who looked like he had been handed an impossible case and knew it, offered a brief rebuttal. He argued that while irregularities had occurred, the appropriate remedy was monetary damages rather than wholesale property transfer, and that displacing hundreds of innocent families would create more harm than it would remedy. He suggested the court could order restitution and allow the homeowners to remain in place under corrected titles. It was a reasonable argument in theory, but it ignored the fundamental legal reality that the land had never been lawfully transferred in the first place. Judge Sutherland listened without interruption, her expression unreadable. Then something unexpected happened. Lorraine Kingsley stood up. Her attorney tried to stop her, putting a hand on her arm, but she pulled away and asked the judge for permission to speak. Judge Sutherland hesitated, then nodded. Lorraine stood at the defense table, her hands gripping the edge, and began to talk. She said she wanted to confess. She had spent the last 2 weeks in isolation, cut off from the community she had once controlled, her assets frozen, her reputation destroyed, and facing the possibility of a federal sentencing enhancement if she continued to deny responsibility. Her attorney had told her that cooperation might reduce her sentence, but more than that, she said. She was tired of carrying the lie. She said she had known from the beginning that the signatures were forged, that the land belonged to me, and that the entire rezoning process had been fabricated to make the sale look legitimate. She said Gerald had approached her in 2016 with the scheme, promising her 8% of the sale price if she could get the HOA to cooperate and push the zoning application through. She said she had agreed. She was in debt because she wanted the money, and because she had convinced herself that one man's unused land didn't matter compared to the housing needs of hundreds of families. She said she was wrong. She said she had destroyed her reputation, betrayed the trust of the community, and broken the law, and she was sorry. The courtroom went silent. Even the reporters stopped writing. Lorraine sat down, and her attorney looked like he wanted to disappear. Judge Sutherland waited a long moment, then thanked her for the statement and said it would be considered as part of the record. The hearing continued, but the confession had shifted the entire atmosphere. There was no ambiguity left, no gray area to argue over. Lorraine had admitted everything in open court, in front of witnesses, on the record. It was over. Judge Sutherland delivered her ruling 2 hours later. She found that I was the lawful owner of the tract, and that all construction, zoning changes, and property transfers related to it were void ab initio, meaning invalid from the beginning. She cited Virginia Code Section 15.2-2107, which provides that improvements made on land acquired through fraud or forgery revert to the rightful owner unless equity demands otherwise. She declared that all residential units and associated infrastructure legally belonged to me as improvements made without the owner's consent. However, recognizing the hardship faced by innocent homeowners, she stayed the enforcement of the property transfer for 90 days, the standard equitable period under Virginia civil procedure for parties to negotiate remedial plans and avoid unnecessary displacement. She made it clear that while I had the legal right to reclaim everything, the court encouraged a resolution that minimized harm to families who had acted in good faith. The criminal sentences came later, but they were a matter of public record. Lorraine Kingsley was sentenced to 8 years in federal prison for mail fraud and conspiracy, ordered to pay $7.15 million in restitution, and had all her remaining assets seized. Gerald Moss received 14 years for wire fraud, forgery, and conspiracy, with an additional $35 million restitution order that would likely never be fully collected. Marcus Holt was sentenced to 18 months in prison and 3 years of supervised release, with cooperation credit. Redwood Pinnacle's bankruptcy liquidation was completed by the following spring, with creditors recovering less than 20 cents on the dollar. I stood outside the courthouse that afternoon, the winter air cold and sharp, and looked back at the building where 9 months of my life had been spent fighting for something that should never have been taken in the first place. Reporters asked me how I felt. I told them I felt tired. They asked what I would do with the property. I told them I would work with the homeowners, that I had no interest in displacing families, and that we would figure out a fair solution. What I didn't say, because it wasn't something that fit into a soundbite, was that I had never wanted any of this. I had just wanted my land back, and I had wanted the people who stole it to be held accountable. And now, finally, they had been. Sometimes the system works. Not quickly, not easily, but it works if you're willing to fight for it. If you believe in holding people accountable when they abuse power, and you want to see more stories where justice actually happens, support Karma Neighbors. This is the kind of accountability we all deserve.